basically, because I was an accredited investor, I could invest in anything. And and I wasn't very discerning at the time. So what, yeah, so I ended up losing most of the money.
Hey, everybody, welcome back to another episode of the Richer Geek Podcast. Today, we have Paul Deloughery. He is, we're going to talk about his journey into the realm of probate law and a little bit about the importance of this. But he's a member of the State Bar of Arizona Probate and Trust Section, Wealth Counsel Certified Family Wealth Advisor. And we're going to talk a little bit about his journey. He unexpectedly inherited and then subsequently had that challenge of, oh my God, I'm young, I've got all this money, what do I do? Yeah, let's spend it. Let's do all this sort of stuff, all those things that you probably shouldn't. So we're going to learn from his story. And he had that realization. It didn't lead just to the founding of Probate Made Simple, but also shaped his philosophy. He wants to offer compassionate, clear, personalized legal assistance to those grappling with the probate process. He's also the author of Lasting Wealth, a revolutionary method of family wealth transfer, and Probate Made Simple. How you doing, Paul?
I'm doing great, Mike. How are you?
Good, doing well. Enjoying the under 100-degree temperatures in Arizona finally.
Amen.
So it's very good. So, Paul, a little bit about, before we dive into what happened with the inheritance, tell us a little bit about yourself and how you became or wanted to become an advisor.
Becoming an attorney. So I was a musician when I was in my 20s, and go figure, I wasn't making a lot of money. So, and some of my students, because I taught, so I actually played bagpipes. Some of my bagpipe students were lawyers, and they always had really interesting stories, and so I was in my early 20s. What did I know? So I went to law school, and at University of Iowa, graduated with honors, all that stuff, and then I got out, and it took me a little while. Like, I tried different areas of law, and during law school, I was also a partner with my mom in a home health agency. So I was running that, and I liked it because my mom was really on a mission to help people stay at home, and prior to that, when I was younger, my mom had a nursing home, a small 22 bed nursing home in rural Lewiston, Minnesota. And so my dad and I used to go on the weekends, and we were the maintenance men. We would paint and try to figure out why the bathroom smelled like urine, or whatever the things was, or get using a screwdriver to get the hair out of the wheels of the wheelchairs and all that kind of stuff. So I just grew up. I grew up doing that, and it's I don't know. So somehow it ended up just being natural for me to get into kind of the area of elder law, and helping people plan for when they get older. So so I got into that, and then I was a partner with John Goodson here in the early 2000s, and he was a well-known attorney for decades, and he did high-end asset protection planning for people around the country, and so I learned from that, and then I felt like what I was doing was a little bit too theoretical, so I kind of was drawn to finally get into probate, and and specifically probate litigation. Probate litigation is the ER of the legal field. I mean, we're dealing with death and dying and incapacity and people fighting over family heirlooms. I've had brothers spend $20,000 each to fight over a $5,000 Rolex watch, and things like that. So yeah, I was involved with that, and then in 2009, I was finally contacted by my biological father. So the dad who raised me, who I was talking about, that was my stepdad, it turned out. Mm-hmm. And I didn't know about that when I was a child. I just knew him as dad. Anyway, so I ended up meeting my biological father for the first time at age 42. He died 6 weeks later. And then, long story short, I ended up going into his house, because I was the only relative. And by the way, like, we had already done a genetic test, and like we figured all this stuff out. There's a long story about why he was not part of my family, or not part of my life. But anyway, so I went into his house, and I looked at his desk, and on here's a big desktop computer and a printer, and on top of the printer was his 2008 federal tax return, and on the bottom of it showed $1 million passive income. So he had what had happened. He had used his military retirement and invested it in penny stocks, and he was just obsessed with it, and learned it. And if you learn something, if you're I guess it was part luck and part skill. He had tons of books and was reading about it and all that. Mm-hmm. Anyway, so he died. I got this, but I ended up getting $28 million. Half of that went to estate taxes, and then the rest of it, you were talking in the introduction about me spending it on this or that. Well, I was investing it. I mean, I thought I was investing it. I invested in oil wells in Texas back, before oil was discovered everywhere, and then the value of that crashed, and then the oils kind of ran dry. They ended up not being as good, and I invested in this and that, and basically, because I was an accredited investor. I could invest in anything. And so I wasn't very discerning at the time. So I ended up losing most of the money. And then I was in a real slump for a while, trying to figure out what in the heck just happened. And, most people looked at me like I was an idiot, and I didn't really know how to explain to them. And then I studied it, and it actually turns out that, there's a saying, shirt sleeves to shirt sleeves in 3 generations. And, basically what that means is, you have one generation that makes the money, second generation keeps it. Well, I didn't do that, but second generation keeps it, and then the third generation ends up blowing it. And it's a common thing. It's they have different versions of the saying in different traditions or different countries, and so the majority, and it's been studied, the majority of financial windfalls that are not kept. It's a real thing. And it used to be back years ago. Now I'm gonna, if the listeners remember when you used to go through the grocery store checkout lane, and the National Enquirer would have, this lottery winner that was won X amount of money and now is in bankruptcy, or this musician or sports star is in bankruptcy, or lost money or whatever, and it was kind of put on there for shock value, and I imagine like the public was supposed to go by and say, oh, what an idiot, think, well, and it in people's minds, I'm sure they thought, well, I would never do that. I would, if I got a $5 million or $50 million contract, I'd be smart with it. But the issue is, and I was kind of talking to you when we first, before we started recording. So there's different levels of awareness that people have, and to get money, to inherit money, or just requires that you have a heartbeat. basically. I mean, it doesn't require any, I mean, if it's something like that, or winning the lottery or whatever, it requires, no consciousness or level of thought or awareness or any of that. Then to accumulate money requires, the ability to do, so the receiving money, that's just, getting, okay. And then to accumulate money, well, that requires, doing something, organizing a business, knowing how to make good investments, that kind of thing. And the trap I ran into was I just thought, well, I'm related to my dad, so and he was smart, so I must be smart, so I must be able to just, instantaneously learn how to, keep the money. Well, no, it required a lot of, bumps and bruises and lessons and all that kind of stuff. But the money didn't last long enough for me to go through that. And so there's, the having money, getting or doing, and then being is more of a, higher, I guess, level where that's where you've gone through life enough, and if you get money, you're okay. If you lose some money, you're okay. That's a different kind of awareness, I guess. And so the interesting thing is most financial advisors, most estate planning attorneys and whatnot, think that you can just kind of create structures and it'll solve all the problems. For example, if you have this trust and you have this will, yes, if everything goes perfectly, if you have if you have your house in a revocable trust and you pass away and there's a trustee named and the trustee is responsible and all that kind of stuff, yes, you can avoid probate. Yes, that's a true statement. But if the beneficiaries or the next generation, if they don't know how to use the money, or they don't trust each other, or they don't like each other, or they don't like the stepmom who's the new trustee, or any of that kind of stuff, they can still end up in court. And so that's actually where I make a lot of my money, is just doing probate litigation, just a whole lot of litigation. And I will say that from my experience, there's, in terms of the contested probate litigation cases I have, there's basically no correlation between if it's going to be in a protracted 2-year-long litigation case and whether there's a trust. There's almost no correlation between those two. You can have a trust and it can be perfect, or it can be litigated, and so it all has to do with the family and whether they're prepared, whether there's it, and it really, I'll boil it down. So for the listeners, for your listeners who have money and want to make sure that things go to the next generation in a smooth way, there needs to be communication. There needs to be trust. It definitely helps to have things documented, for sure. I mean, if you have, this trust says this goes here and that kind of thing, that's definitely good. And there should also be communication, kind of giving a context to that. So in other words, it's not a great idea to surprise your kids with what your documents say and let them figure it out after you're gone. It makes a lot more sense if you care for them, and if you want to prevent contests or arguments later on, have the talk now when you're around, and you can explain, well, I'm giving this house to this son because, this or that. We actually worked on building it together. And, my business, I really want my business to go to this person because, it's, whatever, just so they're, and I'm going to have my youngest child be the trustee just because, they were really good in school, and they're an accountant, and I still love the rest of you, but it's just a choice I made, and just by virtue of communicating that really helps, and hopefully there's some trust. I mean, in the process of communicating it, you'll hopefully learn if there's a lack of trust. I mean, hopefully when you've said that, my youngest child is going to be the trustee, and then some of your other kids say, well, I don't know, I don't think you should do that because this or that. Then you can kind of hopefully address it and try to nip it at the bud.
Mm-hmm.
So I said a lot there, but
that's all right. So, we talk about how can we keep money, there's probate, and a lot of us are more worried. I shouldn't say more worried, but also worried about Uncle Sam getting too much. It's like, look, I've worked my butt off for 3/4 of my life and I want multi-generational wealth. Have you seen anything like within the probate or within the wealth protection? It's to ensure that my heirs get the fair share, or is there, because it goes into probate, it opens up the door for Big Brother to take more of the money?
Well, probate doesn't have anything to do with whether there's going to be tax. So the estate tax amount, there's estate taxes, and then there's capital gains taxes.
Yep.
Capital gains taxes so that's a kind of income tax. Boy, it's a complicated thing. You can plan for that and definitely maximize for it. And depending on the amount of money that you're talking about, it can start getting really complicated. But definitely you can have generation skipping trusts that where it can stay in place more for multiple generations and avoid some of the estate taxes. But anyway, it's luckily right now the estate tax amount is different. And can you hear me okay? Is the sound okay? Oh, okay, great. Yeah. Well, just in a nutshell, I mean, I could talk about techniques and all that kind of stuff, but so there's what I will say is, I think a lot of people get emotional, I guess, about wanting to avoid taxes, and for good reason. But the other thing too is to balance that with all the different other ways that money can get lost. I see money get lost in way more ways that are, I think, more common than taxes. Like just getting squandered by the next generation, or having a caretaker come in, at like during the last year or two of the person's life. Oh my gosh. And that's incredibly common here in Arizona. So it's like a cottage industry. Caretakers come in and all of a sudden, they get put on the bank accounts and all this kind of stuff. And they exclude the kids from being able to, go visit the parent in the care home and all that. And then you're stuck afterwards trying to fix it. And it is a little tricky to, try to avoid that, but it can be done, if you do it proactively. And I guess if maybe the thing is that a lot of people just don't want to think about it, or kind of assume, I hate that word, but people assume that things will just kind of work out. But
so give us some examples of some of the litigation you've done, without specifics, names or anything like that, and how those
Mike,
types of things.
I'm having a hard time hearing you. Is that me?
Yeah, you got me?
Oh, okay. It was me. Yep. Okay. I'm so sorry.
That's okay. Give us some examples of some of the things that you've seen during your time doing probate litigation. And, you mentioned communication with some of them, but, here's the thing is like, hey, if I want that watch, Dad gave it to you, but I still want it. Can the other person, anyone can sue anybody, right? I mean, it just doesn't stop. Or does it say that the trustee goes, you know what? Nope, Dad gave it to you. You get it.
So here, hold on a second. This, yeah, I don't know if I'm having some kind of audio issues here. I don't know what's going on. So can you hear me okay?
Yeah.
Okay. All right. Okay, and you'll have to cut this long pregnant pause out, but let me answer your question this way. There are a couple different ways that people go about fighting over documents. So you gave the watch example. Okay, the trust says that someone's supposed to get the watch and you want the watch. Well, okay, you can't just say I want it. I mean, that's not a legal theory. The court's not going to listen to that. But what we end up doing is looking. There's three main things. One is testamentary capacity, and that just means do you have the mental ability to designate in a document who's supposed to get the watch? Okay, so and that it's a pretty low bar in Arizona, and I think in most states it's a pretty low bar. You need to know who the natural objects of your bounty are and know what you own. Okay, you can think that you're Jesus, you can think you live on Mars, any of that stuff. But as long as you know those things, you still know who your kids are. You realize you're still married or that you're not married or whatever it is, and you know what you own. Then you can sign documents. Sometimes there's a Arizona case where someone had some kind of serious mental illness, and it kind of confused. I mean, they knew who their kids were, but they were confused about their relationship with their kids. So that ended up being a way of disregarding documents. So anyway, so there's capacity is number one. Second one is undue influence. Like I was talking about the caretaker example. So the caretaker comes in and says that the caretaker wants to get the watch, and so you don't get it. Well, if they were involved in having the document signed, or they were in a confidential relationship to your parent, then there's a way of going to court and having it undone that way. And then the other thing has to do with financial exploitation. That's a whole different thing. But basically, yeah. So there are ways that you can attack the documents.
Mm-hmm. Okay.
So yeah.
So let's talk about your book a little bit. Got a couple minutes. Lasting Wealth: A Revolutionary Method of Family Wealth Transfer. Probate Made Simple. Tell us what's in the book.
Okay. Yep. So here, thank you. So Lasting Wealth, basically it tells my story, and I gave you the short version of it. But what I talk about kind of is that there are families who have figured out how to pass wealth from one generation to the next. And for example, the Kikkoman family, okay, in Japan. I mean, they have, that's Kikkoman soy sauce. Everyone knows about that. I mean, that's actually a centuries old company, and there are other examples like that. I mean, there are companies and families that have that remain successful, but it's not typical. And actually, one of the things that they have is I call it a code of honor, and I talk about it in my book. They have like fundamental rules within the family. For example, if there's a dispute, they're going to resolve the dispute, like go in a room, close the door, resolve the dispute, and then when everyone leaves, no one talks about it. Like, that's anyway, just like some rules like that. So that's that. And then the other thing, I have I wrote a book here about Probate Made Simple, and basically it's just how to kind of streamline the probate process. So And so I help people with both areas. Hopefully planning. Hopefully you don't have to go through probate, don't have to have problems in court. But if they do, then we try to simplify it.
Sure, absolutely. And the website, everybody's suddenwealthprotectionlaw.com. Paul, is there anything else you'd like to say to our listeners before we let you go?
No, thanks a lot for having me on. Do you have any questions or?
No. You answered everything. Again, everybody, Paul, with suddenwealthprotectionlaw.com. Check out his books. Paul, thank you very much for coming on the Richer Geek Podcast.
Thanks a lot.